To give you an overview and some of the history about the Camp Lejeune situation, U.S. Marine Corps Base Camp Lejeune, North Carolina was established in 1942. In 1982, the Marine Corps discovered specific contaminants in the drinking water provided by 2 of the 8 water treatment plants on the base. A primary source of the contamination was the waste disposal practices of an off-base dry cleaning firm. The contaminated drinking water at Camp Lejeune started in the early 1950s, and most contaminated wells were shut down in 1985. As many as 1 million military and civilian staff and their families might have been exposed to the contaminated drinking water. There are 3 parts to this discussion: VA disability compensation, the Camp Lejeune Families Act of 2012, and the Camp Lejeune Justice Act of 2022. First, let's talk about VA disability compensation. The VA established a presumptive service connection for veterans, reservists, and National Guard members exposed to contaminated water at the water supply at Camp Lejeune from August 1, 1953 through December 31, 1987, and who later developed one of 8 diseases: adult leukemia, aplastic anemia, bladder cancer, kidney cancer, liver cancer, multiple myeloma, non-Hodgkin's lymphoma, and Parkinson's disease. Presently, these are the only presumptive conditions that the VA recognizes without proof of medical causation. However, if your doctor can link other conditions, you can present that argument to the VA. Next, I want to talk about the Camp Lejeune Families Act of 2012. Under the 2012 Camp Lejeune Health Care Law, the VA provides cost-free health care for certain medical conditions to veterans who served at least 30 days of active duty at Camp Lejeune from August 1, 1953 and December 31, 1987. Qualifying health care conditions include esophageal cancer, breast cancer, kidney cancer, multiple myeloma, renal toxicity, female infertility, scleroma, non-Hodgkin's lymphoma, lung cancer, bladder cancer, leukemia, miscarriage, neurobehavioral defects. Eligible veterans can receive medical services for these 15 covered health conditions at no cost, including copayments. In addition, family members of veterans who also resided at Camp Lejeune during the qualified period are eligible for reimbursement of out-of-pocket expenses for these conditions. This is for payment after their primary health insurance. Next, the Camp Lejeune Justice Act of 2022. Now, what is all the buzz about? This is the Camp Lejeune Justice Act of 2022 that President Biden signed into law on August 10, 2022. The Camp Lejeune Justice Act, which focuses on the 4 decades of water contamination, is just one part of the broader PACT Act we've heard about. The PACT Act, which expands access to health care and disability benefits for veterans harmed by toxic exposure around the world, such as the burn pits we've heard so much about. This is a much broader discussion for another time. But right now I want to talk about the Camp Lejeune Act, which allows military veterans and their families to file a civil lawsuit against the United States government for harm caused by at least 30 days of exposure, including uterine exposure to an unborn child, to water at Marine Corps Base Camp Lejeune, North Carolina from August 1, 1953 to December 31, 1987. This law is unprecedented. The jurisdiction to bring a claim is the United States District Court for the Eastern District of North Carolina, where all claims must be made. The Act precludes the U.S. government from asserting immunity defenses that otherwise would be available in this type of litigation. As a matter of fact, in the past, people have tried these lawsuits and lost for that reason. The law also overrides the North Carolina statute that precludes tort claims after 10 years. Punitive damages are not available. Claims must be filed in federal court within 2 years from the date the law was passed. Awards will be offset by the amount of any disability award. We don't know yet how this will be calculated because the law doesn't spell it out, but it only says there is an offset for VA disability benefits. Even though there is an offset for VA benefits, an award under the law is separate from VA disability claim and outside of the VA benefits. What illnesses and symptoms are presumed to be related? Bladder cancer, breast cancer, cervical cancer, esophageal cancer, kidney cancer, liver cancer, lung cancer, ovarian cancer, stomach cancer, multiple myeloma, adult leukemia, aplastic anemia, Parkinson's disease, renal toxicity, birth defects and birth injury, miscarriage, neurobehavioral defects, and death. Who can file a lawsuit? Anyone who lived or worked at Camp Lejeune during the affected time can make a claim. Claims are not limited to veterans, but also include their families, spouses, and children, and civilian contractors, even if a child was born later and has suffered birth defects. What can be compensated for? These claims are like personal injury cases in federal court. Damages may include medical bills, pain and suffering, lost wages, disability benefits, loss of companionship, consortium, enjoyment of life and earning capacity, permanent disability, and other compensatory damages. Any award received under this litigation will not impede or limit an individual's continued or future entitlement to disability awards, payments, or benefits under any VA program. What documents are needed to file a Camp Lejeune water contamination lawsuit? Documents proving residence at Camp Lejeune, military service records indicating dates and locations served, medical records and diagnosis, medical bills, travel records, health care information, records of disability benefits or VA compensation benefits. You don't need all these documents to start a claim, but the more documentation you have, the better. What's the time frame to file a Camp Lejeune lawsuit? The time frame to file a claim is limited to 2 years from August 10, 2022, which is when the law was passed. If you do have further questions, feel free to call or email me. My number is 502-222-2222 or Karl Truman at trumanlaw.com.